Ladies and gentlemen, it is 4 a.m. in the morning again, and I woke up doing the same thing I woke up doing the other day, thanking. Got me thinking. Okay, Heavy D and the boys. Matter of fact, I was just watching a YouTube video talking about Mr. Heavy D just last evening. Got me thinking. Anyway, I woke up thinking. And I just came up with something. And I will let you know how I came to these conclusions, because I have a young man that I've been helping. He and his family, they have been dealing with a foreclosure. And in dealing with a foreclosure, I've been helping him personally on the side for the last 4 years. As of October, it'll be 4 straight years that they've been in their home. And the courts have been giving them a hard time, giving me a hard time, because they know that I'm helping him. And they've been blocking me every step of the way. But I do what I do. No, I'm not helping none of you. This has been me literally helping him and following everything. And when I put the onus on him to do something, you better believe the onus is on, well, I did it. I don't want to hear it from the rest of you. I said no. But anywho, the court came back at us, and I did a video showing how the court was saying we didn't do this, we didn't do that, we didn't do this. And I slapped them in the back of their head. Oh no, here's proof that we did. The clerk of the court wants to say they didn't receive it. Well, here's proof they signed for it. Then I showed them in a different court where the clerk of the court of that court said the exact same thing, because it's a practice of the court. So now they've accepted the so-called filing and are asking for the briefs. Well, I decided, you know what? Let's change the scripts. What scripts? Same script, different cast. Deborah Cox and Whitney Houston. We're going to change the script. Why? Because I know their game. I have their playbook. So I got to make them change their routine. So I tell you what we're going to do. Now, I'm not joking with this. I believe this right here puts them in a corner, and well, technically by law, the court has no other option because of what I'm bringing to the court's attention. You see, there are certain duties the court must carry out. And now I'm putting the court in that position. Now, these are the rules, but very seldom do they highlight the rules. And in this particular court, this is the rule, and you don't even have to point out where the rule is written. All you got to do is mention it. We'll be doing that for the consultation people. Right now, see, you can't do a class action bankruptcy. That's the only difference. But we are going to do a class action bankruptcy. You'll see in just a moment. You see, that's the unique part, because I just came up with that right now. What do you mean? How do you do a class action bankruptcy? Oh, no. I ain't giving that one to y'all, because this is going to be the first time this was done. You see, that's what I do, y'all. I get technical. What I'd like to tell people is, like the young man I did the consult with yesterday, and I'm going to share this with y'all because I think this is important. Let me segue just for a second. I had an individual threaten me yesterday that he was going to use my past against me. Oh God, no, because he's upset. Oh no, please don't do that. Don't tell people about my past. Oh God, what am I going to do? Anyway, I don't even understand why people think that matters to me. Ladies and gentlemen, I don't care. Go back 30 years, go back 40 years, go back 50 years. I don't care. You're not hurting me. I've already told people, so you act like I'm running from it. Look, here's the thing. You're not going to get this information anyplace else. Go ahead, try. I dare you. And if you could get it someplace else, then why are you worried about me? You follow me? Go ahead. I dare you to go get this information from any place else. Let me see if I can point it out to you. Let me pay attention. Let me see if I can point it out to you. The individual did a consult with me. Somebody was suing him, and the person is suing him through an attorney. Well, the attorney has certain duties and obligations. The attorney didn't fulfill those duties and obligations for his client. But the client for the attorney is the opposing party. So I am doing something while I'm having him do something that hasn't been done before. He's filing ineffective assistance of counsel against the attorney of the opposing side. Why? Because that attorney had certain responsibilities, and because that attorney recommended certain things to his client, which was illegal because he couldn't do what he was trying to do because the law doesn't allow it. He can now hold the attorney responsible because of defamation and libel and slander, because by filing the lawsuit, which he wasn't able to do by law, he defamed the other individual publicly. He brought a false claim on a public record, and if the individual is trying to get business insurance or other type of insurance, he can't, because now there's a claim against him which makes his rates go up and puts him in a bad light. So now he can sue the attorney because the attorney is a learned individual, admissioned, supposed to know the law. And because the attorney should have known what he was doing was unlawful, filing that lawsuit, ineffective assistance of counsel, because now he made his client liable, and as a result of making his client liable, defamation and libel against the party. So he's going to pay attention, he's going to file a claim with the 3 bar associations. 3 bar associations. There ain't no 3 bar association. Yeah, you have the American Bar Association. Okay, that's one of them. Then you have the State Bar Association. Oh yeah, that's right. There's a state bar. So, okay, he's got the state bar and the federal. Where's the 3rd bar? The bar of the court. What do you mean? The court has a bar. He has to be admitted to practice before the court. The court has its own bar. You guys didn't know that? Exactly. You can find out the court's bar by contacting the Supreme Court of the state. Okay? There's an attorney with the Supreme Court who oversees that bar. That's where everybody gets drunk. So I told him, that's what you're going to do. We created the letters, and he's going to complain against that attorney. No, you guys don't understand. It doesn't matter. Well, you can't bring a complaint. Oh, yes, I can. I can bring a complaint against attorneys and ineffective assistance of counsel. This is not a lawsuit. I may not be able to sue on behalf of another person, but I guarantee you what I can do is bring a complaint, because he's an officer of the court. If I recognize him doing something wrong, you better believe I can bring that to the attention of the court. Again, this is what makes me different from everyone else, because this is how I think. And I told him that I know nobody's done this before, and you'll be the first, especially in that state, because I know nobody's done this in that state. Do you feel me? Now, that was just a sideline issue. That wasn't the main issue that the individual was receiving. Oh, God, no. We took care of all the things that they couldn't bring the lawsuit in the first place and killed that, knocked that out of the park. And then we brought a counterclaim. What do you mean? If they couldn't sue him in the court, then how can he bring a counterclaim? Because the counterclaim is the libel and the slander, which is aside from the issues that they couldn't bring in court, because they signed an agreement. The agreement prohibits them from bringing any claims in court. They have a settlement. And they didn't prove that he breached the settlement, so they couldn't bring the action in the first place, and they didn't articulate anything whereby the court would have jurisdiction. So now the court gets jurisdiction in the libel and slander issue. Yay! Oh yeah, we get technical like that. And so he received the information he needed, and ta-da! But getting back to the rest of you guys, when I say that we're going to do a class action bankruptcy under the rules and the laws, go ahead and look. You'll go to ChatGPT and all of them. They say, no, you can't do a class action bankruptcy. The courts have already said this. Not the way we're going to do it. 100% legal. Woohoo! You have no idea what we're getting ready to do, but we're getting ready to do that on behalf of our clients. I've been trying to figure out how we were going to take care of our clients, and now I realize how we're going to do it. So, Fourth Amendment people, that's what we've been working on for you, is figuring the right angle. We have the right angle, especially for y'all's. So stay with us, stay strong, and we will keep it coming. Now look, I got 2 hours and 46 minutes. So I'm going to go get at least an hour more sleep. I told y'all I wake up with this stuff. This is all night long. I've been thinking since 2 o'clock. On and off, waking up, going back to sleep, waking up, going back to sleep, but on the same issue. You try thinking about something for over 2.5 hours straight. Okay? Oh, and by the way, I'm going to say this. For those of you who are wanting to get consultations, y'all going to really need to check yourselves. Y'all don't run the consultations. Some of y'all come in with attitudes as if somebody owes you something. Whew. Now, there are also some of you who scheduled consultations, and it's been a month, 2 months, and you haven't done anything. Y'all gonna have to do something about that because you're messing with my schedule. I don't want you being like the other guy talking about nobody communicated with you. Because my staff, they will let you know, hey, what you doing? Okay, you schedule a consult, it's because you need help. You need the information. So follow through. Now, for the rest of you, my suggestion, and I can only suggest this, just stay tuned to the videos. They're there for you. This information is yours. If you want to, I give enough clues to let you know what I'm doing. You just have to figure it out. Yes. It's like a treasure hunt and all of that stuff because I can't let them know what I'm doing. Okay? And if they think they know what I'm doing, just like I told you guys about a situation, they listen to my videos. If you guys don't understand that people of all profession listen to my videos, lawyers, doctors, and judges, if y'all don't get that, then something is wrong. Look, you can't have this type of experience and have accomplished what I've accomplished and not get the attention of certain people. I told you, I have said things in court and watched attorneys take what I've said and literally use it in other cases to where it got back to me that they said it and I knew they could only have gotten it from one place. Just like I spoke with a friend and he told me in Florida, there is a guy filing he says, and yeah, you can file Chapter 13 to get child support payments reduced. I said, I know exactly where they got that from. I said, I told everybody about it in 2013 when I met the gentleman who was doing it. 400 people getting released from jail because he was filing Chapter 13 bankruptcy for people who had child support. And I told people all cases are involving a debt. If there's a bailment bond, payment bond, and a bid bond, like some people have been suggesting, pay attention. And the courts can show you bailment bond, payment bond, performance bond. That means that there is a debt associated with the case. Pay attention. That means that you can file bankruptcy. Bankruptcy courts are courts of equity. Y'all really need to pay attention. So when he told me that there were people in Florida recognizing that they could file bankruptcy to reduce their child support payments, I said, I know exactly where they got that information from. Well, you can't prove they got that information from me. I said, I guarantee you I can prove they got that information from me. Because prior to that other individual doing it, especially getting people out of jail who were being put in jail because they had not paid child support. There are too many people going to jail for not paying child support. Well, Chapter 13 bankruptcy takes care of that. Like I said, since 2013, I've been shouting it because that guy did it successfully 400 times. And guess what? He figured it out on his own because he did it for himself. And after he did it for himself, he started doing it for others. That's how I know that nobody was doing it before him. Why? Because he didn't get it from anyone else. He just decided to do it. He had no other options. And so he just did it. And even if there was an attorney or somebody who did it before him, they did not make it known to others. So the moment I found out, I told all of you, this ain't about making money off of you. This is about giving you information. But when he mentioned it, I knew where he got the information from. Now go ahead. I don't know everything. And just because I know something and I mention it doesn't mean that somebody else doesn't know the same thing, because we all know the same thing. I've talked about that many times. But what I will tell you is what I think about, you're not thinking about at the same time. You may have the same knowledge, but you're not tapping into that knowledge at the same time, which is why you're scheduling consults. I am here to give you what you need. You talk to the people who I've done consults for, especially the ones lately. They'll tell you that I go above and beyond. Okay? They will tell you that I am thorough. Even one guy, I'm saying, oh, I wasn't prepared to talk about that. You didn't mention that to me. Okay. No, I got you. And then I said, fine. And then I came up with a couple of things and I said, had I not had this conversation with you today, I never would have thought about that because I wasn't thinking along that line, but there you go. And I guarantee you, if you do this, that will work. What, you guaranteeing stuff? Sometimes I can guarantee it. Why? Because of the uniqueness of the situation and the fact they have certain rules they must follow. You guys need to understand something about the courts. There are certain rules that they must follow that they cannot not follow. Okay, pay attention. How do you think I got that court to hear that appeal for that individual? After all the stuff they've been putting them through. That's my job. Why do you think he's still in his property after 4 years? Now, I'm not advocating this. I'm not doing this for nobody else. But he hasn't paid no mortgage in 4 years. So even if he lost the home tomorrow, he was able to be there for 4 straight years. I have another client. There are only 2 of them I'm working with. They've been in their property for 2.5 years now. It's the same routine. Wash, rinse, repeat. Ladies and gentlemen, if you have at least 2 people in your house, file bankruptcy, Chapter 13. Chapter 7. You don't have to file Chapter 13. Chapter 7. Do an adversarial proceeding. Bring up the fact they're not the creditor. I didn't do this with him. Bring up the fact they're not the creditor. Challenge their standing. Challenge the standing that the Federal Reserve is the creditor by law. Prove the Federal Reserve is the creditor, that they're just an intermediary. I've done the videos. That's what you do in your adversarial proceeding. You ask for a trial by jury. Ask for a trial by jury in the adversarial proceeding. And do a withdrawal of the referral by the district court to the bankruptcy court, because original jurisdiction is in the district court. District court had no business referring the case to the bankruptcy court. That was a violation of your rights. You had that right, and the district court took it away from you, and that's unconstitutional. They cannot delegate their responsibility to an Article 1 court in the first place. And you have to do an affidavit of exempt properties listing the house, because household goods includes the home, not just the items in the home. The home is protected. Why? Because it's called the Fresh Start Rule. Go look up the Fresh Start Rule. You need a home, need a car. So each adult is allowed to have a vehicle to get to and from work, because how are they going to pay their bills if they can't get to work? And that's why it's called a Fresh Start. And you need a home to stay in, because where are you going to keep your household goods? Anywho, and you file your adversarial proceeding, you comply with all of their other requirements, and you challenge the standing of the so-called creditor. That will keep you there for 8 months. Then the next person in the house does the same thing, files bankruptcy. Remember, bankruptcy doesn't report to the credit reporting agencies, so they are not allowed to report bankruptcy. Did the videos on that, go watch them. And then they get 8 months. And then you go back and you file bankruptcy, the same routine. There's nothing illegal about it. You can do it, the same documents, same arguments, same paperwork. Even if the bankruptcy court wanted to immediately dismiss it, they can't. They have to follow procedure. And they can't get you for abusing the process because you're taking turns. So there's no abuse there. You feel me? They can't restrict you for 160 days because you're not filing back to back to back to back to back. You feel me? It's what attorneys do. Wash, rinse, repeat. They do it all the time. They'll keep the paperwork going, and that's all you got to do is keep the paperwork going and always appeal. Always ask for a stay pending appeal in the original court and in the appellate court. And you keep the process going. It's just using their rules against them. Now, I could have done that for this gentleman at the very beginning, but that wasn't the case. We have 3 separate cases going. A civil case and everything. We got 3 separate appeals going. I ain't letting that one go because they decided to challenge me. Oh, well. They won't do that no more. All right, look, I said I was going to get an hour's for man, I can't even get an hour because y'all got me still up here talking. So y'all go to sleep. Lord have mercy. All right, I was gone, y'all. Where you at? There you go. Gotta go.